Filing of criminal case for violation of RA 9165.
In the Philippine legal landscape, the control and regulation of dangerous drugs are rigorously enforced, primarily under RA 9165. This legislation sets clear guidelines on drug-related crimes such as the sale, distribution, manufacture, and possession of prohibited substances. Notably, Sections 5 and 11 of this law are critical in combating drug trafficking and abuse by outlining specific penalties and legal repercussions for these offenses, establishing a firm stance against illegal drugs in this country. Section 5 of RA 9165 talks about sale, trading, administration, dispensation, delivery, distribution, and transportation of dangerous drugs and/or controlled precursors and essential chemicals. The elements for this crime to be committed: number one, identity of the buyer and the seller, the object, and the consideration; number two, the delivery of the thing sold and the payment thereof. Section 11 talks about possession of dangerous drugs. On this section, it addresses drug possession, penalizing the unauthorized holding of dangerous substances. The penalties severity under this section is directly tied to the quantity of drugs involved, with higher amounts resulting in stricter punishment. By penalizing possession, the law seeks to curb demand and prevent further offenses, as possession often leads to other drug-related activities. The elements for possession of dangerous drugs are as follows. Person is in possession which is identified to be a prohibited drug. Number two, such possession is not authorized by law. And number three, person freely and consciously possess the said prohibited drug. Violations of Section 5 and 11 incur serious penalties, including life imprisonment and substantial financial fines. Additionally, the law enforces strict liability in many cases, meaning intent to possess or distribute drugs is not necessary to establish criminal responsibility, particularly for possession offenses. This approach underscores the government commitment to both reducing drug supply and demand through stringent regulation and deterrence. Section 21 of RA 9165 shall be further discussed under the chain of custody topic.
I will be discussing the illegal drugs in the Philippines. What are considered illegal drugs in the Philippines? As of April 2023, there are 67 illegal substances listed by the Dangerous Drugs Board. The list includes, but not limited to, heroin, morphine, methamphetamine, hydrochloride or shabu, cannabis, opium, and any other more. Under Section 5 of the Republic Act 9165, any person, regardless of age, status, or gender, caught selling or trading dangerous drugs faces severe charges. The law defines illegal drugs trafficking as any unauthorized act of selling, trading, administering, or delivering dangerous drugs. This includes possession with the intent to sell, regardless of whether the transaction was completed. The charge to be filed against an individual caught selling illegal drugs is typically violation of Section 5, Article 2 of Republic Act 9165. This charge can be filed by the apprehending law enforcement agencies such as the PDEA or the PNP after the arrest. The Philippine Drug Enforcement Agency or PDEA is the implementing arm of the Dangerous Drugs Board. It is the responsible for the efficient law enforcement of all provisions on any dangerous drugs and or precursors and essential chemicals. It shall take charge in the custody, proper disposition, and destruction of all seized surrendered dangerous drugs, plant sources of dangerous drugs, controlled precursors, and essential chemicals, instrument, paraphernalia, and or laboratory equipment, and the representative samples from all law enforcement agencies, forensic laboratories, evidence storage facilities, offices of public prosecutors, and courts, if no longer needed for purposes of evidence in court. Ms. Dayrit will discuss penalties for selling illegal drugs.
Now we proceed with the penalties for selling illegal drugs. The penalties for selling illegal drugs in the Philippines are extremely harsh, reflecting the government's zero tolerance stance on drug-related offenses. The specific penalties depends on the nature, the grade, and the quantity of the drugs involved. The first the first penalty is life imprisonment to death. Section 5 of RA 9165 provides that those found guilty of selling dangerous drugs shall suffer the penalty of life imprisonment to death and a fine ranging from 500,000 to 10 million pesos. However, following the abolition of the death penalty in 2006, the maximum penalty imposed is now life imprisonment. It is critical to note that life imprisonment, as applied in the drug-related offenses, entails no possibility of parole. This means that the individual sentenced to life imprisonment will remain incarcerated for the entirety of their life. And the quantity matters. The severity of penalties also correlates with the quantity of the drugs involved. This is why it is important to follow the proper chain of custody because the quantity of the drugs affects the imposable penalty, and this is to prevent the contamination of the evidences. For instance, if the amount of shabu, marijuana, or other prohibited substance exceeds their threshold, for example, 50 grams for shabu and more than 500 grams for marijuana, the imposable penalty is life imprisonment without possibility of parole. However, for smaller amounts, the penalty will still involve significant prison terms and hefty fines. But the sentencing might be for a more lenient than for large-scale trafficking. Other related offenses and aggravating circumstances in RA 9165. Now, in addition to the charge of illegal sale or illegal drug trafficking, other criminal offenses may arise depending on the circumstances surrounding the arrest. For example, possession of dangerous drugs, Section 11. The mere possession of dangerous drugs is penalized by the RA 9165. If the individual was found with illegal drugs, but there is insufficient evidence to prove that the intent to sell, they could still face charges for simple possession or mere possession, which carries its own set of penalties. Also, the RA 9165 penalizes the conspiracy to commit drug trafficking under Section 26. Even if an individual is not directly caught in the possession or selling, they can still be charged if there is evidence of conspiracy to commit drug trafficking. And also the use of a minor in drug trafficking. If a minor was used in the commission of the crime, this could serve as an aggravating circumstances, resulting in a higher penalty for the accused. Similarly, if the accused occurred within 100 meters of a school or an educational institution, the penalties are also increased. Now, these are the aggravating circumstances.
While RA 9165 focuses heavily on penalizing drug offenses, it also recognizes the importance of rehabilitation for drug offenders. For first time offenders, particularly those involved in possession or minor trafficking cases, the court may consider alternatives to imprisonment, such as plea bargaining or rehabilitation programs. In plea bargaining, in some cases, particularly when the quantity of drugs involved is relatively small and the individual is a first time offender, the defense may opt to enter a plea bargaining agreement. This allows the accused to plead guilty to a lesser offense, such as possession, in exchange for a lighter sentence or alternative sanctions, like community service or rehabilitation. RA 9165 also mandates rehabilitation for certain offenders, particularly those involved in drug use. Courts may order convicted individuals to undergo treatment and rehabilitation for drug dependency as part of their sentence, especially if their first offense and the crime is relatively minor.
Now let's go on to the discussion of the chain of custody. In relation to Section 21 of the Comprehensive Dangerous Drugs Act of 2002, The purpose of this rule is to guarantee the integrity of the physical evidence and to prevent the introduction of evidence which is not authentic. Where the exhibit is positively identified, the chain of custody of physical evidence is irrelevant. Since it is called a chain, there must be links to the chain. The links are the people who actually handled or had custody of the object. Each link must show how he received the object, how he handled it to prevent substitution, and how it was transferred to another. Each must testify to make the foundation complete. According to the case of People versus Gayoso, GR number 206590, it was a case in March 27, 2017. The links in the chain of custody are first seizure and marking, if practicable, of the illegal drug recovered from the accused, turnover of the illegal drug by the apprehending officer to the investigating officer, turnover by the investigating officer to the forensic chemist for laboratory examination, and the last one is turnover and submission of the marked illegal drug by the forensic chemist to court. On the other hand, failure to comply with the chain of custody, according to series of cases, does not automatically make the seized items inadmissible. However, the non-compliance of such may affect the evidentiary value of the seized items or evidence.
Now, let us discuss the procedure to be followed in the custody and handling of seized dangerous drugs. When law enforcement seizes drugs or related items, there's a protocol or specific protocol they follow to make sure everything is properly documented and handled. And here's how it works. First, inventory and photos. Right after the items are seized or confiscated, the officers will create a list or inventory of what they took and photograph these items. And who needs to be present during the conduct of this inventory and photograph? First, the accused or the person or persons from which such items were confiscated and or seized. Next is his or her representative or counsel. And third, a representative of the National Prosecution Service or the media. And lastly, any elected public official who shall be required to sign the copies of the inventory and be given a copy thereof. These persons must be present to witness the inventory and photos. Next is lab testing. Within 24 hours of the seizure, the items shall be sent to the Philippine Drug Enforcement Agency or PDEA for testing. The forensic lab examiner has 24 hours from the time they receive the items to complete the tests and issue an official source certificate with the results. Next is inspection and destruction. Once a criminal case is filed, the court will inspect the items within 72 hours. After this inspection, PDEA has 24 hours to destroy the drugs to prevent any misuse. And then the final documentation. The Dangerous Drugs Board will then issue a sworn certification confirming the destruction or burning, which is filed with the court. They'll also submit small representative samples of the seized substances to PIDEA for safekeeping and evidence. This procedure or process ensures that seized drugs are fully documented, tested, inspected, and then safely destroyed after a court review, with each step verified by multiple officials to maintain the integrity of the evidence.
Moving forward, let us proceed to the procedure in criminal cases with relation to the violation of RA 9165. Here, we still follow the rules of court. However, there are internal rules or guidelines issued by the PIDEA, particularly on Section 21 of RA 9165, as amended that we need to observe. This section will be more elaborated in the succeeding slides. So first and foremost, it will be initiated by either the filing of a complaint or a warrantless arrest. We'll deal with the part under warrantless arrest since this is the one common in drug cases. So in warrantless arrest, the usual is when the suspect is caught in flagrante delicto or caught in the act. After that arrest, inquest proceedings shall be done. If there is no probable cause, it will be dismissed. On the other hand, if there is found by the prosecutor, the case shall proceed. An investigation shall be done by the prosecutor. He will then forward his resolution to the city or provincial state prosecutor. If this is approved, then the filing of information will commence. To continue, the accused has the right to request a bail hearing. However, bail is not automatically granted in serious drug cases. Basically, it will all boil down on whether the quantity of drugs is large and whether the evidence of guilt is strong, and if it is not punishable by reclusion perpetua or life imprisonment. In such cases, the offense may be non-bailable. During arraignment, the accused must be present. He will enter a plea of guilty or not guilty. Of course, the common scenario here is the accused entering a plea of not guilty. In this case, a pre-trial, then a trial will proceed. Judgment is then rendered by the court. If the prosecution has proven the accused's guilt beyond reasonable doubt, he shall be convicted. Take note that this decision is not final. He has a legal remedy to file for an MR appeal. If, however, the prosecution failed to establish his guilt, the accused shall be acquitted. Also, take note that before the death penalty was abolished, the case is subject for automatic review to the Supreme Court if the penalty is death.
Further elaborate on the chain of custody requirements in drug-related cases, please take note of the following. The team that seizes and takes control of dangerous drugs and other related items must immediately, after confiscating these items, conduct a physical inventory and take photos of the seized items. These must happen in the presence of the accused or the person from whom the items were taken or their representative or lawyer, along with an elected public official and a representative from the National Prosecution Service or the media. These witnesses must sign copies of the inventory and each must receive a copy. If the items are seized with a search warrant, the inventory and photos should be done at the location where the warrant is seized. In cases of warrantless seizures, this can happen at the nearest police station or office of the apprehending team, whichever is practical. If there are valid reasons for not following these requirements, the seizure and custody of the items will still be considered valid as long as the team preserves the item's integrity and evidentiary value. The forensic laboratory examiner must issue a certification of the lab examination results immediately after receiving the items. If the volume of drugs or the chemicals is too large to complete testing in the standard time frame, provisional report should be issued, listing the amounts still to be examined. A final certification must be provided once the examination and certification process is fully completed.
Good day. I'm Vicar John Painaga. Today I'll be discussing an important aspect of the Comprehensive Dangerous Drugs Act, specifically the implication of non-compliance with Section 21 of the Republic Act 9165 or the preservation of seized items in drug-related offenses. Section 21 of RA 9165 lays down guidelines on the handling, custody, and integrity of seized items, specifically dangerous drugs, to ensure their proper handling as evidence in court. This section emphasizes strict adherence to procedure by law enforcement, particularly during bypass operations or drug apprehensions. A critical point to understand is that non-compliance with Section 21 is not necessarily fatal to the case. The Supreme Court has clarified that even if law enforcement officers deviate from this procedure, the validity of the arrest or admissibility of evidence is not automatically compromised. This means that the accused arrest is not rendered illegal, nor are the confiscated items inadmissible as long as two important conditions are met. First, there must be reasonable, acceptable reason for the apprehending officers could not strictly follow Section 21. Second, the integrity and evidentiary value of seized items. The evidentiary value and integrity of seized items must remain intact. This is crucial as the integrity of the evidence directly impacts the credibility of the prosecution's case. Why the integrity of this evidence is vital? To secure a conviction for the illegal sale or possession of dangerous drugs, the existence of the drug, referred to as the corpus delicti of the crime, must be irrefutably established. If there is any doubt regarding the authenticity or handling of the seized items, it could lead to the acquittal of the accused. Thus, the primary objective of Section 21 is to avoid any possible tampering, substitution, or contamination of evidence. While strict adherence to Section 21 is ideal, non-compliance does not immediately jeopardize the case against an accused, provided the integrity and chain of custody of the seized items are unbroken. Ultimately, it is the preservation of the evidence's integrity that plays the pivotal role in determining the accused's guilt or innocence. This focus, evidentiary integrity, upholds the fairness of the judicial process and maintains public trust in law enforcement procedures. Next slide. In the prosecution for illegal sale of dangerous drugs, what is material is proof that the transaction or sale actually took place and not whether the arresting officers complied with Section 21 of RA 9165 or not. In continuing with our discussion of RA 9165, the Comprehensive Dangerous Drugs Act, I'll now focus on a key point in prosecuting the illegal sale of dangerous drugs. Specifically in the cases, it's not the procedural compliance with Section 21 that is most crucial, but rather the actual occurrence of the drug transaction itself. The essential elements of illegal drug sale. In cases involving the illegal sale of drugs, such as shabu, the law emphasizes proof of the transaction rather than the technicalities of compliance with Section 21. For a successful prosecution, there are two main elements that must be established beyond reasonable doubt. First, identity of the buyer, seller, object, and consideration. This means that the individual involved in the transaction, the buyer and seller, must be clearly identified, along with the actual item being sold. In this case, the illegal drug and the agreed upon exchange or consideration for the sale, which is typically the money. Second, the delivery and payment. The second essential element is the illegal substance must be actually be delivered to the buyer, and the buyer must complete the payment. This exchange is the crux of proving the occurrence of the sale. Why these elements are key? Once these elements are confirmed, the offense of illegal drug sale is considered complete. The court's primary focus is on whether the transaction itself occurred as alleged. This focus supports the principle that the act of selling illegal drugs is the offense, and thus the physical transaction is what makes the sale illegal under RA 9165. In Section 21, compliance, a secondary concern, while compliance with Section 21's procedures, such as proper handling and documentation of seized items, is important for preserving the integrity of evidence. It is not an absolute requirement to prove the sale itself as long the prosecution can establish the occurrence of the sale through clear and credible evidence. The essential offense has been committed. In summary, for the prosecution of illegal drug sales, the law requires that proof of the actual sale and the exchange involved be established first and foremost. Once these core elements are confirmed, they form the foundation for a conviction. Section 21 compliance, while significant for the handling evidence, does not take precedence over the proof of transaction in the prosecution's case. In closing, understanding this distinction in RA 9165 strengthens our comprehension of how drug offenses are prosecuted by focusing on the actual transaction in cases of illegal drug sales and ensuring the integrity of evidence in seizures. The law strikes a balance between the procedural safeguards and the decisive proof needed for conviction. This careful approach reinforces the importance of due process and helps uphold justice in drug-related cases. Thank you for your attention and engagement throughout this discussion.